Thanks to those of you who have returned to witness the evidence that I'm going to present, which exposes the abuse of power by the appointed public officials involved in Alex's trial. Thank God I have finally figured out how to use Judge Fries's interpretation of Indiana law during the trial to prove that anyone driving while intoxicated and causes the death of another person commits reckless homicide, not murder. Quote Judge Fries, page 582, lines 3 through 14. To convict the defendant, Alexander Orta, of count 1, murder, a felony, the state must have proven each of the following essential elements beyond a reasonable doubt. 1. The defendant, Alexander Orta. 2. Knowingly. 3. Killed. 4. Another person, that is, Craig Toner, by striking Craig Toner with his vehicle, causing him to die. If the state proved each of these essential elements beyond a reasonable doubt, you may find the defendant guilty of count 1 murder. In Alex's case, this translates as, to convict Alexander Orta of murder, the prosecutor is obligated to prove that he was operating his vehicle with a specific intent to kill Craig Toner by striking Craig Toner with his vehicle, causing him to die. And the reason the intoxication defends against the charge of murder is because the intoxication proves that Alex was too drunk to operate his vehicle with the specific intent to kill Craig Toner. Quote Judge Fries, page 473. Voluntary intoxication would for legal purpose be raised to instruct the jury that if they found there was voluntary intoxication, they could conclude it was reckless but not knowledge. That would be defending against the charge of knowledge. The reason Alex was wrongfully convicted of DUI murder is because his defense attorney, James Corporal, put on a defensive strategy that deprived Alex of presenting the evidence of intoxication to the jury to prove that he was too drunk to operate his vehicle with specific intent to kill Craig Toner. Proof of Corporal's defensive strategy is that he allowed Prosecutor Dvorak to withhold the charge of DUI before the trial and still charge Alex with DUI murder. The charge itself is enough to prove that Alex's attorney sold him out because the charge itself overrides Indiana state law, specifically Code Section 354125, which provides lack of intent by reason of intoxication. Further proof of Corporal's defensive strategy is in these statements made by Corporal in Alex's defense. Quote, defense attorney James Corporal. The legislator is saying, okay, prosecutor, you have to prove that this person was operating while intoxicated and caused death, but you don't have to prove that he knowingly did anything, unquote. Quote, but they're taking it one step further, and I think Sanchez does too. I've got to admit, I think it does too. It not only precludes you from having that as a defense, but I think it precludes you under Sanchez if you buy into that the defendant can't even talk about intoxication, unquote. Since Alex's defense attorney was putting on a defensive strategy that deprived Alex of presenting the evidence of intoxication to the jury, when Alex says that he wanted to testify on his own behalf, Judge Fries informs the attorneys that if Alex testifies and puts the intoxication into issue, that he himself will tell the jury that the intoxication is proof of Alex's innocence to the charge of murder. So to keep Alex from testifying, his attorney convinces him not to testify about his intoxication because admitting that he was voluntarily intoxicated is the same as admitting that he was acting with specific intent. How that makes any sense, I have no idea. To sweeten the deal about not testifying, his defense attorney tells Alex that if he doesn't testify, that he will request that the prosecutor make available a lesser included charge of reckless homicide. What Alex's attorney failed to tell Alex was that the jury would never be allowed to consider Alex's mental state to determine if he knowingly or recklessly killed Craig Toner. So his attorney uses the evidence of intoxication. So when his attorney uses the evidence of intoxication to request a lesser included charge of reckless homicide, Judge Freeze explains that the lesser included charge of reckless homicide is literally a defense to the charge of murder. On pages 486 through 489, the judge even goes as far as requesting that the attorneys allow the jury to consider the intoxication because the intoxication is in the evidence and proof of Alex's innocence to the charge of murder. Prosecutor Carter's response makes it very, very clear that Alex's defense attorney is refusing to acknowledge Judge Freeze's request. The reason the defense attorney refuses to acknowledge the judge's request is so that he can allow Prosecutor Carter to convince the jury that they cannot consider Alex's mental state at the time of the accident to determine if Alex was operating his vehicle with specific intent to kill Craig Toner, or if he was too drunk to operate his vehicle with the specific intent to kill Craig Toner. Quote from Prosecutor Carter's final argument: "If there's any indication there's intoxication in regard to whether he knowingly did something, toss that out. You don't worry about the intoxication." Unquote. This statement removes the state of mind requirement from the charge of murder and allows Carter to convince the jury that killing Craig Toner by striking Craig Toner with his vehicle causing him to die is enough to convict Alex of murder. Quote from Prosecutor Carter's final argument: "Why is this different from any other DUI causing death? Why is Mr. Orta guilty of murder? Because he got back in and drove over Craig Toner." Unquote. These two statements made by Prosecutor Carter in his final argument are enough to prove that Carter failed to meet his burden of proof that Alex knowingly killed Craig Toner. All of Carter's final argument contradicts Indiana state law. On pages 582 through 587, Judge Freeze's final interpretation of Indiana law to the jury makes it very obvious that the prosecutor failed to prove that Alex knowingly killed Craig Toner because the jury was never allowed to consider the intoxication to determine if Alex knowingly or recklessly killed Craig Toner. Judge Freeze makes it very clear that if the jury was not allowed to consider the intoxication, they can't find Alex guilty of murder. And here's the proof. Quote, Judge Freeze, page 583, lines 6 through 19. "Before you may convict the defendant of reckless homicide, the state must have proven each of the following essential elements beyond a reasonable doubt. 1, the defendant, Alexander Orta. 2, recklessly. 3, killed. 4, another being, that is Craig Toner, by striking Craig Toner with his vehicle, causing him to die. If the state proved each of these essential elements beyond a reasonable doubt, you may find the defendant guilty of reckless homicide, Class C felony, a lesser included offense of count 1 murder. If the state failed to prove one or more of these essential elements beyond a reasonable doubt, you must find the defendant not guilty of count 1. Further proof that Alex's defense attorney sold him out is in the fact that he allowed the prosecutor to charge Alex of killing the same person 3 different times in one trial. Count 1, murder. That's a homicide charge. Count 2, operating a motor vehicle with a controlled substance in the blood resulting in the death of another person. That's another homicide charge. And the lesser included charge of reckless homicide. Quote Judge Freeze from page 519, lines 23 through 25, and page 520, line 1. "Why do you say that they must find him not guilty of murder, or say that they cannot find him guilty of murder, which I think is the more accurate statement?" Unquote. As you can tell, the judge took it very personal when the defense and the prosecuting attorneys walked in his courtroom looking to dispense vigilante justice. Thank God.